As exciting and fast-paced as real estate can be here in Ontario, one of the most stressful things that buyers and sellers have to consider is if the deal falls through. While this is a fairly rare occurrence, especially in today's hot market, it sometimes can crop up and should be dealt with in a calm and guided manner. In today's video, I'll cover what defaults are and some common examples from a buyer and seller's perspective. I'll also be discussing the rights and liabilities of parties in a failed closing and some considerations on how to minimize the legal fallout. Hey guys, if you're new to this channel, my name is Chris Chu and I'm a real estate lawyer here in Toronto. And on this channel, I'll be sharing some information, tips, and insights into the laws surrounding real estate in Ontario so that you can feel better prepared when tackling your next real estate transaction. Now, before we get into the video, I'm obligated by the Law Society of Ontario to let you know that all the content on this channel is for informational purposes only. Nothing on this channel should be construed and should replace legal advice. The content on this channel does not form the basis of a lawyer-client relationship. So, let's start off by addressing what a failed closing means. Essentially, a party defaults at closing if either buyer or seller can't close the deal on a scheduled day as agreed in the agreement of purchase and sale. The reasons why either party can't close the deal can be endless. Some common examples of why buyers can't close the deal are their mortgage didn't get approved, they couldn't get their down payment fund secured, personal issues such as divorce, illness, or death, or, and this is a super rare case, if they're just generally being a jerk and decided not to buy the property at the very last minute. Sellers can also have similar reasons, such as sickness, death, or any kind of family issues, inability to close on a new home that they were planning on purchasing and moving into, if they haven't moved out yet for some reason, their tenant is refusing to leave, and again, if it's a rare scenario, generally they're just being a jerk and refusing to sell the home at the very last minute. Now, one of the options that's available to the buyer, and it's under very strict circumstances, is that they may be able to sue the seller for what's called specific performance. And that is a law that basically makes the court obligate the seller to sell the property to the buyer. Now, this is a super rare legal remedy that isn't usually available to most people. In essence, the buyer needs to show that the property was supposed to be sold to them and was so unique and so particular that the whole deal hinged on it. You'd have to essentially prove why another home wouldn't suit your needs. So unless you're buying some celebrity home or even buying Disneyland, let's say, to live in, chances are this remedy isn't going to cut it. Now, let's talk about remedies that are more commonly available to both buyers and sellers. A more common legal remedy is suing the defaulting party for damages. Now, what damages means is that the party that is ready, willing, and able to close can sue the other side for the financial cost of failing to complete the deal. So if the seller can't complete the deal, the buyer can ask the court for damages for the difference in the price of a similar home they had to buy after the transaction failed, and all the carrying costs associated with the hassle for looking for a new place, such as inspection fees, contractors, realtor fees, legal fees, hell, even mileage if you had to drive around a ton. Here's an example of how things can get really costly and out of hand. Say the seller refuses to close on a home at the very last minute, and that home was selling at $1 million. If the buyer starts looking for a new home, but the market is so hot that the prices have risen significantly since the closing of that home for a similar location and size, and now it costs $1.5 million, if the buyer goes through with a new purchase at $1.5, not only does the buyer claim the difference of $500,000, but they can also claim the cost of hiring movers, contractors, lawyers, everything under the sun in terms of dealing with the fiasco of a seller refusing to close the deal at the last minute. Likewise, the buyer who fails to close the deal can expect to be sued by the seller for the difference on the purchase price of the home, if the price is dropped, which is pretty unlikely in this market, the carrying costs for continuing to have the property like insurance, condo fees, mortgage payments, and property taxes, and the cost of arranging the sale, which is the realtor fees, legal costs, even movers. Now again, here's a really costly but plausible example of what can happen from a seller's point of view. If the buyer refuses to finish the purchase of the home at $1 million and the property values have since dropped by $200K, not only can the seller claim the difference in the price drop of $200K, but they can also claim for the carrying costs of having to manage the home, which would include mortgage payments, realty taxes, legal fees, and all the associated costs that the realtor had to carry as well. Now, it's important to keep in mind, guys, that these examples are hypothetical and are pretty extreme scenarios. However, I think it's important for you to understand just how much risk each side is bearing if they refuse to close the deal. Now, one of the most important things to note is that suing for damages is governed by the legal rule of mitigation. What that means is that if a deal fails to close, the innocent party can't just sit there and have a pity party. The non-defaulting party has to act as fairly and efficiently as possible to minimize their loss. So, if the buyer gets cold feet at the last minute and backs out of the deal, The seller can't just refuse on trying to relist the property. Now, before we get any further into talking about the different types of remedies that are available, I think it's important to discuss what happens to the deposit. When a deal firms up here in Ontario, it's common practice to have the buyer pay a portion of the purchase price as a deposit to the seller's side, usually to their broker or lawyer, to hold until the deal is closed. Now, if the deal fails to close and there's no movement on either side to somehow close the deal, the deposit is either forfeited to the seller if the buyer defaults, or it's returned to the buyer if the seller defaults. Let's talk about the two other options that don't require you to go to court if a deal falls through. The first one is a release. Essentially, with a release, the innocent party can choose to release the defaulting party of liability and risk of a lawsuit if they agree to certain terms. Now, the terms are subject to each party and their lawyers coming to an acceptable agreement. In almost every case, a release will probably involve the deposit being forfeited or returned. It would be wise to also include payment of the other side's legal fees associated with the deal itself and any reasonable carrying costs such as interest on the mortgage or property tax payments if you're the seller. Now, the advantage of this remedy is that it is a lot less time consuming and costly than litigation. The innocent party gets a chunk of change for the troubles and can move on as quickly as possible with finding a new person to close the deal with. The defaulting party also gets the benefit of limiting their legal exposure by paying out a set amount of money and being promised that a future lawsuit won't come back to bite them in the ass. Now, the risk of a release is dependent on the facts itself. That said, releases sometimes don't work if both sides come up with outrageous terms and costs, or the defaulting party just has no money. The second and most commonly used option in dealing with defaulting closings is extending the closing date itself. The innocent party can agree to extend the closing date so that the defaulting party can get organized and find a suitable way to close the transaction. It's reasonable for the innocent party to charge a fee for extending the closing and also getting the carrying costs paid off for the closing itself. Now, it's important to remember that an extension does not mean the deposit is refunded or forfeited. Unlike the two other remedies above, this one is essentially treating the transaction as still being active and pushed to a later date. Now, in my opinion, this is probably one of the best options for sellers and buyers since the deal can actually go through. Both parties can walk away relatively happy since they got what they wanted. It's also the cheapest remedy and usually the least time consuming, depending on how long the delay actually is. The downside, however, is that it doesn't offer a sense of certainty. If the defaulting party can't get their act together, even after an extension, then the innocent party can be stuck with an even higher carrying cost and would still need to pursue a release or litigation. So let's tie this all together. What does this all mean? In most cases that lawyers deal with, litigation for a closing is the last thing that we prefer to happen. Not only does it take a long time to get to court, it's also the most costly avenue. Each case of default is fact specific, but making sure that you're trying to keep the deal alive and then escalating up the ladder of remedies can be your best bet. That's it, guys. Thank you so much for watching, and I hope you enjoyed the video. If you're looking to get in contact with me about a legal matter, you can reach out to me and set up an appointment via my firm's website, which I put a link in the description below. And make sure to like and subscribe and tune in for more awesome content. I'll see you guys soon.